Hello everyone, good afternoon and welcome to panel 5A. My name is Rawia Rifad and I'm a PhD researcher at the University of Exeter, and it is my pleasure to chair this panel today, which is the third vulnerability session that focuses on gender identity and sexual orientation in refugee status determination. As I'm sure we could all agree, asylum seekers who base their claims on their gender identity or sexual orientation are often one of the most vulnerable groups as they attempt to prove an identity within an often stereotyped policy used by decision makers. They often face unthinkable trauma before arriving in a safe country, only to face a difficult process of proving their need for refugee status. It is an important area that requires a vast amount of research and collaboration with this group to help better and improve our understanding so we can reform asylum processes and policies together. We have three fantastic speakers today, Marisa Afghari, Dr. Jana Vessels, and Dr. Nicole from ASYFAIR. It is now my pleasure to introduce our second speaker today, Jana Vessels. Jana is an assistant professor of migration law at the Amsterdam Center for Migration and Refugee Law at VU Amsterdam. She previously held research posts at Gießen University in Germany and the University of Technology, Sydney, Australia. Her presentation today draws on her book, The Concealment Controversy, Sexual Orientation, Discretion Reasoning, and the Scope of Refugee Protection, which will be published with Cambridge University Press in June 2021. Jana's presentation for today is titled Invariably Discrete, Refugee Status Determination in Germany and France and the Intricacies of Discretion Reasoning. Jana, the floor is yours.
Thanks very much, Rawia, and thanks to the organizers, including you, Nicole, for inviting me to this conference. As I am looking for the presentation, there we go. Yeah, I want to use the next few minutes to reflect on sexuality-based asylum claims in German and French jurisprudence and on what it tells us about the intricacies of discretion reasoning. Before I start, I have a couple points. It would be really great if some of you could turn on your videos. It's really strange to be talking to like nobody, so thank you. That's much better to be looking into people's faces. Yeah, thanks. And then the second is that you'll see that my presentation is really brief. It really is only the outline for you to hold on to. So if you cannot follow, let me know. Also, if, as Rawia said, it's based on my book, which is somewhat delayed, so it should come out now on the 19th of July. That's what Cambridge promised. So if you're interested, that's where I develop the arguments much more fully, of course. Yeah, so I think my presentation nicely follows on from what Marisa just did. I want to argue that the two distinct ways in which discretion reasoning emerges from or in German and French decision-making practice are each somewhat paradigmatic for the broader intricacies of discretion logics that are inherent in the refugee definition of the 1951 Convention, as Marisa just laid out. So I will use them as examples to illustrate some broader observations. So I'll proceed as follows. I'll first briefly outline the decision-making practice in both jurisdictions and then discuss how they relate to three specific tensions. Okay, so starting with a brief analysis of how discretion reasoning emerges from decision-making practice in Germany and France. When we look at these two countries and their jurisprudence, it's striking that while in both jurisdictions there is a tradition of discretion, the underlying reasoning emerges as opposed, whereas France has traditionally sent claimants back to discretion, so rejected their asylum claims and sent them back to their countries of origin based on an absence of public expression of their sexual orientation. Germany has a tradition of returning claimants if their sexual identity isn't deemed sufficiently stable. And I'll briefly explain this in somewhat more detail for both countries. So in France, the focus on the claimant's behavior was specifically or explicitly introduced in the first definition of social group relating to sexual orientation in the late 1990s. And the definition required that the claimant had to be gay and assert their sexual orientation or manifest it in external behavior. And the notion of external manifestation required that the person had publicly revealed their sexual orientation or presented external signs that rendered the sexual orientation visible and evident in the eyes of society in which they lived, in parentheses, the persecutors, right? Based on this requirement, in what has been termed this discretion requirement in reverse, because essentially they required non-discretion, recognitions were granted to those claimants who had then manifested and shown their sexual orientation, whereas those who had maintained their sexual orientation secret were rejected. So what happened here in these cases, even though a claimant in France might have been accepted to actually be gay, and persecution of gay people was established in the relevant country of origin, the social group was understood to extend only to those who also expressed their sexual orientation to the persecutors. In contrast to France, Germany has always had a focus on identity and rather than acts. And in that sense, German practice was closer to what might be called the classical discretion requirement. And in a leading 1988 judgment, which is relatively early, of course, for this kind of claims, the German Federal Administrative Court developed a distinction between, on the one hand, those who were irreversible, on the one hand, irreversible, fateful, and inescapable homosexuality, and on the other hand, latent homosexuality. Now, in the former case, where a person was thought to be determined by their sexual orientation to such an extent that they had no choice but to satisfy their same-sex sexual urges, that's how they framed it, homosexuelle Triebbefriedigung. That was the first case, and the latter case, people had a mere inclination, bloße Neigung, towards same-sex sexuality, and in the reasoning of the court could therefore choose whether or not to engage in same-sex sexual acts. And based on this classification, then only those claimants who could convince courts that their identity was indeed sufficiently and irreversibly determined by their sexual orientation would then be granted protection, regardless of whether anyone, including a potential persecutor, might be aware of this. So in this reasoning, then, even though a claimant might engage in same-sex sexual behavior, this would not warrant protection if their identity that connected to that was not considered to be sufficiently determined by the same-sex sexual orientation. So here the social group only extends to those claimants whose identity was deemed sufficiently stable. So in both jurisdictions, we don't find an explicit requirement of discretion, right? The discretion requirement, which was established in UK jurisprudence and led to HJ Iran, HT Cameroon, etc. But discretion emerges from this act identity dichotomy by default. So in France, those who had not manifestly expressed their sexual orientation were sent back to continued discretion, and in Germany, those whose identities were not sufficiently shaped by their sexual orientation were likewise also sent back to continued discretion. Interestingly, the CJEU judgments that rejected the discretion requirement in 2012 on religion, in 2013 on sexual orientation, the twin judgments, if you will, have in substance had a negligible impact on decision-making practice in this regard in both these jurisdictions. After a moment of uncertainty that's visible in jurisprudence, both jurisdictions appear to have found ways to incorporate the new developments in jurisprudence and guidance from the CJU into their established decision-making cultures. So in Germany, what happened is that courts continue to assess whether the claimant's identity is sufficiently shaped by their sexual orientation. And they were able to do that because they have misinterpreted a paragraph from the Y and Z judgment on religion, to the extent that in the assessment of the asylum claim, it's now required that the behavior concerned must be significant and particularly important for the identity of the claimant. This is paragraph 70 in the Y and Z judgment. Although this paragraph does not appear in the subsequent X, Y, and Z judgment on sexual orientation, which is obviously the much more relevant case or judgment for this type of claim, and although it is a bit of a misreading, this interpretation has allowed decision-making practice to essentially remain the same. So the notion of that we had previously had irreversible determination was simply replaced by particular importance. And in France, courts now no longer explicitly require past public manifestation, but they continue to make a backwards facing risk assessment where claimants will have difficulty in establishing risk if they have not suffered from persecution already in the past. And that will obviously only occur if they have been outed or have been imputed to be gay in the past. So have not passed or have not passed unnoticed by the persecutors. And this is based on the notion that the social group is defined by the way in which these persons are viewed by the surrounding society or institutions. However, under this notion, in order to qualify for protection, the claimant has to explain why they personally are at risk. So they must explain why they would be considered to be a member of the group by the persecutor. And that is difficult to do if it's not relevant whether they in fact are gay, but that they will come to the attention of the persecutor, right? Because it's their perception that's relevant. Okay, so having seen the decision-making practice in these two jurisdictions, I now want to use the remainder of the time of the presentation to argue that the way German and French courts have approached these issues are paradigmatic examples for two kind of different approaches to the intricacies of discretion reasoning that arise from a web of tensions and that are inherent in the refugee definition. And I'll illustrate this with regard to three different tensions. So the first one is a clash between the fundamentality principle and the severity argument. The debate on discretion is characterized by two central notions in refugee law that are in principle uncontroversially shared in refugee law doctrine. And I've labeled them fundamentality principle and severity argument. So the fundamentality principle consists in the generally accepted idea that no one should be required to hide, change, or renounce the attributes or opinions that are persecuted. That's found in UNHCR guidelines and in judgments everywhere. The rationale is that if hiding were required, then there would of course be no need for refugee law at all, right? The severity concern, in turn, is based on the shared understanding that refugee law provides surrogate protection for serious harms. The logic is that the task of refugee law is not to guarantee the same level of rights and freedoms everywhere in the world, as human rights law generally would, and therefore to remedy even minimal or trivial harms, but rather that refugee protection extends only to injuries of a certain quality. Now, refugee lawyers generally subscribe to both these notions. The problem is that they clash. No hiding, which is inherent in the fundamentality principle on the one hand, but not the same freedoms, the severity argument on the other hand, are difficult to reconcile. Not the same freedoms require some measure of hiding, and no hiding requires the same freedoms. And this tension creates an intricate situation for the convention grounds. Hiding is required and forbidden at the same time. And we see that Germany and France each approach this tension differently. In France, the emphasis on the behavior, the externalizing act, appears to favor the fundamentality principle. There should be no requirement to hide. If they act, then they're protected. if they decide to act, right? Whereas in German jurisprudence, there appears to be the severity concern appears to be favored. Only if the sexual orientation is of such importance that they really cannot but act on it, and then it's severe enough for them to be entitled to protection. So in a situation of conflict, both jurisdictions then opt for favoring the opposing elements, and we see that this happens through the separation of the convention ground, that sexual orientation in this case, into acts on the one hand and identity on the other, right? So the act-identity dichotomy serves to respond to this incoherence. The persecuted characteristic sexual orientation is split into acts and identity, and either can serve as the convention ground, right? And therefore uphold the fundamentality principle. And the rejection this simultaneously allows the other element. So if they opted for act in terms of the convention ground, like France, the other element to float free and to expand, or rather also limit the definition elsewhere in the assessment, and thus ensure that the severity concern is also met through a degree of discretion. So in that way, the claimant is entitled to the convention ground and restricted from it in conflicting ways. And we can clearly see how this plays out in the jurisprudence from Germany and France, right? Another tension that plays out in the jurisprudence is what I call the Refugee Convention's paradoxical double rationale. And what I mean by that is that we do not really know exactly what the Refugee Convention, the Convention's main purpose is, what it intends to protect, because it protects from persecution, which is carried out by persecutors, on account of a reason which is located with the claimant, and over which the claimant has some degree of control in many cases. So, is the main motivation of refugee law to be seen in the protection of the convention grounds, given that persecution for other reasons is not protected? Or is it protection from persecution, given that other harms on the basis of the convention grounds are not protected, the triviality? So the fact that both are laid out in the definition as necessary conditions also creates a dilemma. Persecution is relevant only if it's due to the convention ground, and the convention ground is relevant only if it is met with persecutory harm. And when we look at decision-making practice in German and French jurisprudence, we see that here too, in this tension, both jurisdictions favor opposing elements, right? The French approach, with its focus on externalizing behavior, appears to be particularly concerned with protection from persecutory harm. It's not much fussed about protecting the sexual orientation as such, but rather zooms in on those situations which are likely to lead to harm, or rather have already led to harm, right? And people who have always remained in the closet and never been imputed a gay identity by others are not so much of concern to the French system. In contrast, in German jurisprudence, with its focus on the identity, it seems that they're mainly concerned with protecting the convention ground. And you know, some acts which might be carried out by someone whose sexual orientation is considered to be fleeting or whatever, and could and therefore, you know, very well bring that person to the attention of the persecutor, wouldn't matter so much to the German jurisprudence, because in their assessment it doesn't arise from a determined and stable gay identity, and so would not be entitled to protection. So here we see how the positioning in response to the tension between convention ground and persecution can have real consequences for the claimants concerned as well, right? And this is also the case for the last third and last tension that I want to briefly highlight, and that is the question of whether we focus on the claimant or the persecutor for defining what the convention ground is, right? There is also tension as to whether we focus on the claimant or the persecutor in order to understand what is persecuted. As I said earlier, the convention protects from persecution, which is carried out by persecutors on account of a reason which is located with the claimant, and over which the claimant has some degree of control. So the claimant is in a position to reduce the prospects of serious harm precisely by exercising control over the reason which triggers this harm, for example, by hiding it entirely or by manifestly asserting it in external behavior. So they have influence on the degree of the risk, but they can never fully control it, right? And that's because persecution must be for a reason, and it's the persecutor will only submit the claimant to harm that is relevant under the convention if they identify and take that individual to possess that characteristic. But it always remains the persecutor who determines the parameters of what and who is persecuted, right? And it's by no means clear that the persecutor will correctly identify the right persons as gay, nor is it clear which signifiers they will use for that assessment. And that's why it's clear that the convention does also protect those who are imputed to be gay. In that regard, approaching the convention grounds by establishing first in abstract terms, and that's what happens by reference to human rights. So if we try to define the convention grounds by establishing in abstract terms what they involve and then assessing whether the claimant possesses these characteristics, then that whole exercise may be completely out of step with the persecutor's notion of what they think is political or gay in this case, right? And therefore with a group that's in fact targeted by the persecutor. In some ways, it's completely irrelevant whether we think in our assessment that whether the person is in fact gay or not. The only thing that really matters is that the persecutor thinks this, right? But on the other hand, an approach that relies entirely on the persecutor's perception without establishing the claimant's actual identity has then difficulty in identifying those individuals that would be at risk. Therefore, such an approach is prone to singling out logics. So where a claimant, it's not sufficient that they are gay, but they have to show that they have been or would be singled out for persecution, right? And that's often connected to a backward-looking analysis requiring past persecution. And that's what we see in German and French decision-making practice. The French approach, which does adopt this persecutor's perception for defining the persecuted group, falls prey to that backward-looking analysis, essentially requiring past persecution in order to establish group membership on the basis of imputation. And German practice, in turn, which is with its focus on the claimant's deep inner identity to establish group membership, applies a definition of the protected group, which is potentially much narrower than the actually persecuted group by defining out those who are not, in their view, sufficiently gay, right? Okay, so those were the three tensions that I think play out neatly when we look at the German and French jurisprudence. And so to quickly conclude, what we've seen is that German and French jurisprudence on sexuality-based claims each build on discretion reasoning, and their reliance on this act-identity dichotomy, the distinction between act and identity, allows them to navigate some of these fundamental tensions that are built into the refugee definition in opposing ways. But I think what the final point I want to make is that it's important to note that while one of the elements in every concrete situation of each of the tensions is always preferred, the submerged one is also there, and it does some work, sometimes unnoticed, right? And I've said this with regard to the act-identity dichotomy, how the other element can be, do reductive work in a different element of the refugee definition. I think the same goes for the other tensions as well. So while this work that the submerged elements, that the non-preferred elements in a concrete situation may be exclusionary or reductive in many cases, there may also be emancipatory potential in these tensions. So they can be maybe in some cases harnessed towards to counter the predominant approach and to in a given situation enable broader protection by making the point that the other element kind of can undo the exclusion that the main one did, right? Okay, so that's all from my side. I look forward to your questions and discussing further. Here's also the information for my book and a discount code in case you're interested. Yeah, I look forward to questions.
Thank you, Jana, for your really interesting presentation. I'm now pleased to introduce our third and last speaker today, and that's Nicole, who is also co-organizing this conference today. Nicole is an anthropologist with extensive research experience in migration and refugee studies. Her ethnography on refugee resettlement in the UK laid bare the practice policy gap in the UK's migration service provision. She is the lead researcher for the ASYFAIR research project, and as a native German speaker, she is responsible for research conducted in Germany and Austria. Nicole has published on refugee resettlement policies and experience in the UK, as well as on the asylum adjudication in Europe. Nicole's presentation today is titled Subjective Judicial Assessment of SOGI Claims at German Asylum Courts. Nicole, please, you have 20 minutes for your presentation.
So thank you very much for having me, and thanks for the great turnout in this panel. I'm here on behalf of my research team, especially Dr. Nick Gill, but also Jessica Hembley, who collaborated with us on this presentation. And here I draw on our ethnographic data from our German research and argue that the utilization of credibility in SOGI claims is often problematic, as the assessment of SOGI claims is often based on subjective perspectives of judges that may go beyond what Petro Susna called heteronormativity. Yes, I will not bore you long with our research methods, as most of you already know. We have conducted legal ethnographies, together with some statistical data collection at courts, as well as conducted some interviews in Italy, Greece, and the UK, and our publications can be found on our website. Before I present some ethnographic examples, I want to mention some very important disclaimers. So firstly, we did not specifically focus on SOGI claims. We did not deliberately select them during our fieldwork at courts, and we only came across them coincidentally. And we are still in the analysis and writing up stage at this point, so the other speakers in this panel are probably better placed to talk about the law and conceptual ideas. We also observed very few SOGI cases during our fieldwork at courts. We therefore struggled to make universal claims. Rather, I present some case studies from Germany, where I actually only observed 4 SOGI cases out of 282 cases overall, so a relatively small sample. In France, my colleague Jessica observed more SOGI cases. Some of them were via video link, which introduces additional problems, which unfortunately I don't have the time to discuss today. Also, all the cases I present here today concern gay men rather than any other sexual orientation or gender identity, and is therefore further limited. Now, very importantly, we have selected distinct examples for this presentation that we found quite problematic, and some members of the audience may find equally problematic. So I present them consciously to provoke a discussion on the real life experience of some SOGI claimants and European courts, and perhaps some questionable views that some judges hold. And as a research team, we are aware of the problematic terminology in SOGI cases. So I want to emphasize that what I present here are verbatim comments, and the ethnographic examples do not reflect the views of the ASYFAIR research team. Now, I'm sure you are all familiar with the CJEU ruling from 2014 concerning homosexuality. And for example, it argues that discrete examination must be in accordance with the sensitive nature of questions relating to a person's personal identity, and in particularly their sexuality, and must take into account the individual position and personal circumstances of the asylum seeker. Assessments must guarantee their rights enshrined in the EU Charter of Fundamental Rights, and cannot be negatively assessed just because the sexual orientation was not revealed from the outset, and asylum seekers refuse or struggle to reveal intimate aspects of their life. However, there are also problems whether certain questions or assessments are appropriate. So this ruling also set out some impermissible assessments, for example, questions about sexual activities, requesting any images or videos of sexual acts or carrying out medical examination into the sexual orientation. That was just a brief run through some of the key points. Another aspect of the CJEU ruling was the discretion argument, where the CJEU ruled that applicants for asylum cannot be reasonably expected to conceal their homosexuality in their country of origin or to exercise reserve in the expression of their sexual orientation. The fact that the applicant could avoid the risk by exercising greater restraint than a heterosexual in expressing their sexual orientation is not to be taken into account. So considering this point of the CJEU ruling, I was very surprised when I came across the following case in summer 2018 at a German court, a hearing that I have observed. The case was chaired by a young female judge and concerned a young male appellant without a legal representative, and it should be highlighted. The man was accused of raping his male roommate in his country of origin and had to leave his country of origin after repeated threats by the former roommate's relatives. From the hearing, I could not quite deduce if the sexual act was consensual or non-consensual, and in fact, the applicant really struggled to understand the interpretation of consent. And the judge clearly didn't seem to expect a SOGI claim. She appeared rather rattled when the applicant stated that he is gay. And she took too long a breaks in between the hearing to, in her words, quote, look something up, unquote. And what surprised me here were the questions she asked towards the end of the hearing, which I show here. So, for example, the judge asked, what would happen if you would return to your country of origin and marry a woman? How would that make you feel? Or what would it mean to you if you would return to your country of origin and live your sexuality in secret for the sake of your family? When the appellant did not understand what the judge was asking, she added, well, there are gay men in your country of origin and they keep it secret and meet secretly. And she also concluded in one of the final mentions she made in the hearing was, the German law allows for refugee protection for homosexual orientation, but only if you want to live it openly, and you would be persecuted for openly living this life in your country of origin. So our style of questioning, we could argue, is not quite in accordance with the CJEU ruling, and I would suggest from what I have seen that the judge seemed unfamiliar with the discretion argument from the CJEU ruling. But moving on to subjective credibility assessments. So in Keegan's words, subjective assessments are highly personal to the decision maker, dependent on personal judgments, perceptions, and dispositions, and often lacking an articulated logic. They're very difficult to review and are likely to be inconsistent from one decision maker to another. And I want to give you here two quotes from judges that I have spoken with in Germany. So one that Nick already mentioned yesterday when he talked about bias in his keynote, one judge said to me in a conversation, I'm surprised with the population boom in some African countries, considering that so many of the asylum seekers claim to be homosexuals. So clearly we already have some problem here. It might be what could be considered a tongue-in-cheek comment, but it reflects the prejudices some judges may hold that SOGI claims are not genuine and that sexual orientation is nothing more than a so-called asylum tactic. Another judge said in another court case, refugee protection due to homosexuality requires that I am convinced that you were significantly shaped by your homosexual identity, but I have my doubts. And this example shows that judges are aware of their subjectivity, but are vocal in telling asylum applicants in court that their gay identity may be put into doubt. Assessments may also be based on culturally biased understandings of sexual orientation, which affect their assessment of the credibility and may have direct bearing on the understanding of the risk involved in their deportation. Now, without a doubt, the most uncomfortable hearing I have attended out of the more than 280 I have seen in Germany, that hearing was not only Eurocentric, but also quite inappropriate and inconsiderate. In the hearing, I had the feeling that the personal, perhaps even prudish view of the judge shone through more than in other cases I have observed. There was a young judge, fairly young judge, and a young male appellant who did not have a legal representative. Again, very important to note that. So the male appellant, just to give you a bit of a background, he had a sexual relationship with his male co-worker. They were both working as garbage collectors, and they were caught in a sexual act at their workplace, and that's why he had to flee his country of origin. The judge asked the following question. Now, you tell me that you had sex with someone who collected garbage all day. That's not very appetizing. I can imagine that after a day of work, without a shower and without a change of clothes at a landfill site, that this is not particularly nice. I find this hard to believe. To which the appellant replied, we're not like Europeans. The appellant also outlined that he and his partner watched pornography together. Again, the judge said, just so I understand, you started to have sex with a colleague after you watched pornography in the car together. And again, the judge expressed later that he does not believe the appellant when he says that. At the end, the judge also said in a very stern tone, like a school teacher, almost blaming the appellant for what has happened. So why would you have homosexual intercourse with someone on a landfill site where other people are and where you could be discovered? And the appellant tried to explain that there was no other place that they could have met. So these questions about personal hygiene in connection with sexual practices such as watching pornography together, actually, we believe tells the judge nothing about the sexual orientation or the credibility of the sexual orientation of a person. As an anthropologist, I would go as far as to say that we can almost speak of a Eurocentric pollution belief, in which the credibility is assessed by a Western yardstick beyond heteronormativity. I find it hard to believe that you had sexual relations with someone without taking a shower, is one of these examples. Judges may also raise questions about Sochi relationships. Here we have a case of a middle-aged male judge and a young male appellant who did have a legal representative. And the appellant explained, just to give you a background, that he broke up with his partner, with his same-sex partner in his country of origin before he left, or before they were discovered and he had to leave. So the judge asked, so you were with your partner for 10 years, but you decided to just leave him and leave the country. After all you have gone through together, you just leave him behind? I find this hard to believe. And the appellant tried to explain that the reasons his partner stayed behind and that they are currently not in touch because they had a fight, and he hinted there at some kind of infidelity. But the judge went on to say, so after 10 years, you just say, I don't care, I find this dispassionate, but this is more of a comment now. And to this, the lawyer retorted, these are matters of the heart. Gay people are also allowed to look for a new partner. So such questions they doubt the credibility because the claimant has broken up with his partner, and the judge kind of implicated that because they went through trials and tribulations together, therefore they have to stay together forever. And such questions concerning the doubt of credibility may also affect claimants, something that Marisa also mentioned earlier. If Sochi claimants have been married in the country of origin, I have also seen a case where the judge questioned, well, how can you be gay if you have been married before to a not a same-sex partner, as well as being an active member of the gay scene. In the Sochi cases I observed, there were constant questions about what gay clubs are you going to in Berlin, and are you on Grindr, which is an app for casual sexual encounters, if you want to call it. Now, in our conceptualization of religious conversion cases, we have came across the eyes of the persecutor test, and we think this may be rather useful. So Keegan writes, rather than assessing the credibility and sincerity of an asylum seeker, assessment should be based on the persecution that arises in the eyes of the persecutor in the country of origin from both the observed or ascribed behaviors that lead to the persecutor to perceive that the victim is a member of the targeted group. And Jana has pointed out the shortcomings of this approach. So of course, this is not 100% ideal. So maybe still in the cases that we have seen, there was very little focus on persecution in the country of origin. So maybe the focus should shift to the persecution. So for example, in the first case I presented to you about the consensual or non-consensual sexual act between roommates, the appellant actually had evidence that he was threatened in his country of origin, which the judge ignored. Now, some other suggestions which may not resolve all the problems for SOCI claimants, but maybe for a few, and it may still be helpful for judges refocusing the assessment of persecution rather than these credibility assessment. So building here on other literature, on the vast body of literature that exists in SOCI asylum claims, we would also argue that judges should take into account sociocultural factors. For example, a lot of people have been married in their country of origin due to concealment or due to cultural practices such as arranged marriages. That doesn't mean that they are not gay. Also, as I have shown with the examples today, real life experiences may differ from the judge's expectations. So yes, people do watch pornography together. Yes, people might not have a shower before they engage in sexual activity. Some of these issues, of course not all, just a few of them could perhaps be mitigated if judges would receive further training, as I emphasized in the first case study, familiarize with CJEU rulings, but especially also not employ stereotypes, as I mentioned before, being active members of the gay scene in the country of refuge. And judges should focus on the persecution in the country of origin rather than credibility assessment. And again, Jana has already pointed out the shortcomings, and I'm happy to discuss this in the discussion in the Q&A. Thank you very much.
Thank you, Nicole. That was a fantastic presentation. And thank you to all of our other speakers today. That draws our presentations to a close.